Welcome to Module 3, Contemporary Curriculum, Instruction, and Assessment Matters. In this lecture, I will specifically highlight contemporary legal issues affecting students, families, and schools. You may be interested in researching one of these issues for your EDN 300 project this semester. Before we begin, hit the pause button and brainstorm on paper the first 10 amendments to the U.S. Constitution, known as the Bill of Rights. Next, place an asterisk next to those you feel most affect our roles as teachers working in public schools. Keep this reference sheet for later in the lecture. The objectives of this lecture are as follows. You will be able to explain the legal basis for public education in the U.S., identify which U.S. constitutional amendments relate to school law, and evaluate the responsibilities and rights of teachers and students relative to contemporary legal issues, such as freedom of speech, freedom of religion, and search and seizure. In the United States, the basis for our legal rights is derived from the Bill of Rights in the 14th Amendment. In addition, each state has its own constitution. Some rights, such as education rights, are delegated entirely to the states. First, let's review the Bill of Rights. How many did you remember? Which do you feel are most applicable to teachers' and students' rights in public schools? We will now discuss briefly education law and policy and how school cases are heard. As previously mentioned, the basis of our legal rights is founded in the U.S. Constitution. Each state also has its own constitution. Here's the North Carolina General Assembly website, for example, where you can search the statutes by keyword. Chapter 115C is dedicated entirely to the North Carolina elementary and secondary education laws, further subdivided by articles that relate to specific roles and responsibilities or issues such as school personnel conduct, school violence prevention, and much more. Specific to education law, each school district has its own policies. Here, for example, is the New Hanover County Board of Education Policy Manual found online. When cases are heard from the local to the state level, they must be appealed to the U.S. Court of Appeals, or the circuit courts, which decides appeals from the district courts within its federal judicial circuit. There are 11 numbered circuit courts, as shown on this map, and 13 total, including D.C. and the U.S. Court of Appeals of the Federal Circuit, with 179 judges who are authorized by Congress and nominated by the President of the United States. As seen here, North Carolina is located in the Fourth Circuit. Cases heard by a circuit court may then be heard by the U.S. Supreme Court. The Supreme Court, however, hears fewer than 100 of the more than 10,000 cases filed annually. Thus, most federal cases stop at the circuit courts. There are two important legal terms about which you should be familiar as school teachers. The first, parens patriae, is Latin for parent of the nation. It is the authority of the state to protect the well-being of children by usurping the rights of the natural parent if a child is being abused or neglected. The second is in loco parentis, or Latin for in place of the parent. This refers to the legal responsibility of a person or organization, such as a school, to accept some of the roles and responsibilities of a guardian. This is applied to schools and colleges to act in the best interest of students. In the next few slides, I will outline constitutional rights and related court cases. First, let's begin with freedom of speech. Freedom of speech is protected under the First and 14th Amendments of the U.S. Constitution. The First Amendment reads, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. U.S. citizens have certain rights to free speech, and the government must have a compelling justification to curtail this expression. Although they are minors, children and adolescents do not lose their rights to free speech. Traditionally, school officials could restrict student expression for just about any reason. Since the mid-20th century, however, particularly since the landmark case Tinker v. Des Moines, the Supreme Court has recognized that students do not shed their constitutional rights at the schoolhouse gate. In 2009, many First Amendment supporters celebrated the 40th anniversary of Tinker v. Des Moines. Photographed here are 13-year-old Mary Beth Tinker and her 15-year-old brother John, who wore these black armbands to show They're mourning for the people killed in the Vietnam War and for their support for a truce at Christmas. Mary Beth was suspended immediately by her principal, who said that no black armbands would be allowed. Although her family received death threats as a result of her silent protest, Mary Beth felt that she had the right to express her political beliefs at school. The majority opinion in Tinker v. Des Moines held that student speech is protected unless school officials can reasonably predict that it will disrupt the educational process or invade the rights of other students. As a result of this case, the court affirmed that students do not shed their constitutional rights to freedom of speech and expression. This does not imply that students can say whatever they wish, however. There is speech that is not protected by the U.S. Constitution, including defamatory expression, such as slanderous statements that are false, obscene, lewd, or vulgar expression, and inflammatory expression, such as speech that agitates or threatens others. Importantly, when considering whether speech is protected under the First or 14th Amendments, it must be determined whether it is speech at all. The courts also determine whether the speech is private or school-sponsored, as we'll see in the following case. 20 years following the Tinker v. Des Moines case, on January 13, 1988, the U.S. Supreme Court ruled in Hazelwood School District v. Kuhlmeier that public school officials could censor a school-sponsored student newspaper if they have a legitimate educational reason. In this case, the principal of Hazelwood East High School, a suburb of St. Louis, objected to 2 articles in the Spectrum that dealt with teen pregnancy and divorce. Several students sued in federal court, claiming that censorship violated their First Amendment rights. They referenced the previous case, Tinker v. Des Moines, arguing that school officials could not censor student expression unless they could reasonably determine that the expression would cause a substantial disruption. They also argued that the school newspaper was a public forum for expression, entitled to greater protection under the First Amendment. In a 5-3 decision, the majority argued that the school newspaper is not a public forum, but part of the curriculum over which school officials maintain control. Justice Byron White then created a new standard for school-sponsored speech, whereby schools can refuse speech for legitimate pedagogical concerns that are inconsistent with the shared values of the school. Technology has created a whole new arena for legal conflict. Recently, students and teachers alike have been suspended for what they have written in blogs and on Facebook. In 2006, for example, a high school student was suspended for cyberbullying after she created a Facebook page stating an English teacher she had was, quote, the worst I'd ever had. 4 years later, in 2010, a Florida court ruled that she can take action against her former school to expunge the penalties from her school record, as well as sue for a nominal fee for violating her First Amendment right. In April 2011, a New Jersey school district suspended a first-grade teacher after parents complained that she had posted derogatory comments about her students on her Facebook page, stating she felt like, quote, a warden, and she called her students, quote, future criminals. This teacher was removed from the classroom after her Facebook page was made known. These are just 2 of dozens of cases reported recently in the media regarding First Amendment rights in social media. These cases call into question the rights of students and teachers to freedom of speech on the internet. You may be interested in researching these legal matters for your project this semester. Keep in mind that as teachers, your behavior is guided by not only what is legal, but also by what is ethical. You are expected to have a high standard of professional ethics and to be a role model to others. Unethical acts can impair a teacher's reputation and may have him or her removed from the classroom. An additional First Amendment right is freedom of religion, including the separation of church and state. The First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. As this amendment is directed toward the federal government and education is primarily a state function, most church-state controversies in the schools have been initiated through the 14th Amendment. Adopted in 1868, this amendment prohibits state and local governments from depriving citizens of life, liberty, or property, and has been used to apply the Bill of Rights to the states. This is a photo of David H. Kurtzman, a defendant in the landmark Supreme Court decision Lemon v. Kurtzman. In 1971, in a unanimous 7-0 decision, the Supreme Court ruled that it was unconstitutional for the state of Pennsylvania to reimburse private schools, many of which were Catholic, for the salaries of teachers who taught secular content and used secular textbooks and secular instructional materials. The majority ruled this public funding of private schools, even though they were teaching secular and not religious subject, violated the Establishment Clause of the First Amendment. The Supreme Court's decision in this case established the Lemon Test, consisting of 3 prongs. The government's action must have a secular legislative purpose. The government's action must not have the primary effect of either advancing or inhibiting religion. And the government's action must not result in excessive government entanglement with religion. Some justices have been dissatisfied with the Lemon Test and prefer the endorsement clause, or the endorsement standard, in which a government action must be struck down if an objective observer views it as endorsing or disapproving of religion. Some also use the coercion test, in which a government official, directly or indirectly, is viewed as coercing an individual to profess a specific faith. General outcomes from court cases involving religion in public school include that schools cannot sponsor daily prayer and Bible reading, but that schools have the right to engage in private devotional activities in public schools as long as they do not interfere with regular school activities. Holidays with both secular and religious significance can be observed in an objective and prudent manner in public schools. There is some controversy over schools' silent prayer statutes, however. Most are upheld as constitutional. Next, we will discuss search and seizure. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. An important Supreme Court case relative to search and seizure is New Jersey v. TLO. This case involved the search of a high school student for contraband after she was caught smoking in the school bathroom. A search of her purse revealed drug paraphernalia, marijuana, and documentation of drug sales. This student, whose initials were TLO, was charged as a juvenile and subsequently fought the search, claiming that it violated her Fourth Amendment rights against unreasonable searches. In a 6-3 ruling, the majority argued the search was reasonable based on the evidence that the student was smoking in the school bathroom. 2 tests of reasonableness resulted from this case. First, is the search justified at its inception? Are there reasonable grounds for suspecting that the search will turn up evidence that the student has violated or is violating either the law or the rules of the school? And is the scope of the search reasonable? In other words, are the measures adopted reasonably related to the objectives of the search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction? A school law case that had a different outcome than TLO was Safford United School District versus Reading. This case was heard in 2009 and concluded that a strip search of a middle schooler for ibuprofen violated her Fourth Amendment rights. A classmate wrongfully accused Reading of supplying prescription-strength ibuprofen, and based upon this false report, school officials searched Reading's belongings. When they found nothing, they conducted a body search. They did not find any contraband on Reading, and they did not contact Reading's parents at any time during the search. The case was heard by the district, which found no Fourth Amendment right violation. The Ninth Circuit later agreed, but then reversed its decision. In an 8-1 majority vote, the Supreme Court held that the search did violate Reading's Fourth Amendment rights. The individual school officials, however, were entitled to qualified immunity and do not face further charges. In search and seizure cases, it's important to consider one's expectations of privacy. School lockers, for example, have a lower expectation of privacy as lockers are school property. In fact, some states have enacted laws that eliminate any presumption of privacy in school lockers. Students have greater expectation of privacy in their personal property or effects. According to Cameron McCabe and colleagues, warrantless searches of a student's person raise significant legal questions. In summary, school officials cannot simply have a hunch in order to perform a search. School personnel need reasonable suspicion before they search lockers, personal belongings, or individuals. In this lecture, I've outlined a few of the many legal issues involving students, teachers, and schools. There are clearly dozens more. For your contemporary curriculum instruction and assessment assignment, you may consider researching a legal issue as we've explored in this lecture. Clearly, each of these impacts teaching and learning and society at large. Here are a few additional examples, but you are not limited to these ideas as well. You will visit several websites outlining other educational matters to consider your research topic this semester. As always, please do not hesitate to contact me with any questions as you begin your work.